hospital. And so I got to see them. What is going on there? Rear camera. That's weird. Okay, that one works. Why doesn't the other one work? Rear camera. Oh, it's just zoomed way in. That's what it is. What is going on here? Oh my goodness. And then today is technically the deadline for our next set of research stuff for presenting at the national conference in March. So I gotta get those out today too. View, admit all. Here we go. Okay. Let's see here. So we are actually here today. Yay. All right, spotlight for everybody. Welcome to, this will be evidence. We're actually here today. Thank goodness for that. So Monday, I hope you guys got that. I'll actually show you guys that because it's funny as heck. One of those things where it's like computer stuff. You can't trust that stuff at all. So if I go down here into evidence, you can see under announcements right here where I had to cancel class on Monday. If I click this and say save, it sends that as an email. But for some reason, whenever I did that on Monday, it didn't do that in here. And at least one of my courses too.
I got the
Okay, good. Because it didn't show me that. It showed me in like 2 of the 5 different places I posted it. Oh, that's.
I showed up to class, like there was one other kid in your room, or during 3 courses of class periods, like I showed up and I was like, oh shoot.
Yeah, everybody quit today. No, just, and then Wednesday was rough because I was actually here for the first part of the morning, and then I got a little bit demoralized and I left. It's like with the Google sign up between Google outages and the updating of passwords on the annual basis kind of thing. It locked me out of all of the systems with my laptop. So it's like I can intermittently check email on my phone, but that's not the same thing.
What about the Wednesday before? Because I could get this into
the Wednesday before I was actually out to SWAC. So
okay, so I haven't missed
you haven't missed any. So we missed 3 in a row.
Okay.
Yeah.
I feel so much better because my mom was getting on to me. She's like, you need to go to class.
But only when we're here. And unfortunately, so we missed 3 classes in a row, but good news is we're not that far off of the syllabus. Okay, good.
That's weird. Showed up for me.
Yeah, because it didn't show up in my outbox because it usually shows up in my outbox whenever I send those because they're supposed to link up, and for some reason, nothing electronic like me this week or last really. Yeah, it's been a long week already. It's just Monday. But if we get down here, we're about a week off is what it looks like. We should be finishing chapter 8 last week, but we had that's good stuff and then outages and all that. So we're not that far behind. I've gone ahead and I popped out quizzes 3 and 4 for this section. So that'll cover chapters 5 and 6 and 7 and 8. They'll take the same form as I can stop right now. Stop share. Okay, there it goes. And so the quizzes will take the same form as the previous 2 quizzes we had with their looks like 20 points, something like that. Unlimited number of attempts for these, 60 minutes to take it. And so it takes as many times as you want. Highest grade stands. Good way to also practice for the test. We'll do a review for the test here in a minute. We'll go through the PowerPoint, make sure there's nothing else I haven't talked about related to those confrontation clauses, the last thing in chapter 8 that we were covering. And so when we're done with that, we'll do a review. And depending on how fast that goes, we may roll into chapter 9, the exclusionary rule, because this is where it starts getting a little bit more fun from my perspective, because you have the verbal stuff and all that, but when you start getting into some of the evidentiary procedures, this is where you really get the evidentiary procedures in terms of like physical, tangible things. And so the rules here work a little bit different, but this is when we're dealing with it. Well, in terms of physical stuff, but in terms of like how we deal with it, it's a little bit different than the spoken word, that kind of thing. So let's take a look and see where we left off with that PowerPoint last time, because it's been too long. I don't remember. Let's see, that would have been chapter 8. Let's see where it takes us. Conference 8, enable editing. It didn't show me where I left off. All right, well, let's just start rolling through it then, see if any of this stuff. Okay, pre-Crawford test for admissibility, testimonial statement, rule Crawford versus Washington, hearsay being used for admission to out-of-court statements. So these are learning objectives. So we'll go into each one of these. State the rule for admissibility, non-testimonial statements, that kind of thing. I want to say we talked about some of this stuff. All right, so we know the confrontation clause. The whole reason we have subpoena processes that we do. There's a huge element of being able to face your accusers, and so that way you can be able to test those accusations. And if you can't test the person who's accusing you, you can't face them, you can't test it. And so that's why we have these processes in here. When it comes to the things that we can make you to say, we can make you say anything that we tell you to say, except for in the instances where it incriminates you. And so that's kind of the law there. When it comes to hearsay, we're talking about the fact that we've heard someone say something, but we can't really attest to anything but the fact that it was said. And so, yeah, out of court statements, as evidence, the person making the statement is a witness who is not confronting the accused. They're just making a statement about what was said. All right, so prior to this, it was not extended. That confrontation clause is only in criminal trials. Oop, too fast. Pointer versus Texas, 14th month due process, confrontation clause is binding state criminal court. So this is kind of walking you through the time order of this. This is something you'll see here in evidence a little bit. Procedures does it a bit more so because it's more focused on those Supreme Court cases that change those procedures. So basically what you'll see here is the general pattern is whenever there's an issue arise, whether it's a criminal case or if it's just, criminal case, lawsuits, all that kind of stuff. They'll have a bearing on the procedural side, but keep in mind that whatever the original context of that case that went through that changed something, that's the context in which it applies. What I mean by that is that if it's a federal case dealing with federal statutes, federal officers, federal situations, when that first case goes through and it makes it through, it's only going to apply to the federal level, that kind of thing. Whereas if you start at the state level, usually it'll work its way up, that kind of thing. And so repeatedly through time, you'll see that whether it's the confrontation clause, the exclusionary rule, those basic elements that protect us from government overreach, as well as give you your rights. Essentially, it'll put teeth in it so that way that stuff can't be used against you. All of that is going to start usually at the federal level and probably the most serious of cases, like you're with the exclusionary rule. I want to say that started out with it's a murder case. I'd have to go back and look at that one, but it was a state level thing, or not state level, it was federal. And from federal, then it starts to move into, okay, is it federal? How serious of a crime is it? Felony, is it a misdemeanor? Where does this thing apply at? And so that's going to be running through this too to some degree. And that's why I started out talking about, okay, it started out in the federal system, it moves into the state. 1970, recognized face-to-face contact between witnesses and accused for cross-examination. Here we go. Indicative of reliability. That's I can say that. How's that? That's basically what it is. We just want to be able to test this. If you can't come in and say it, then that's not an accusation we should give merit to. Okay, following questions help identify correct solution for admissibility awkward statement. Is it hearsay? Is it testimonial? If it's testimonial, it requires cross-examination. If it's not testimonial, no confrontation. Forfeiture by wrongdoing apply. I'm sure that one has to deal with. That's probably not to deal with that. It's some type of admission statement as well. I'd have to go back and look at that one. Basically, what it is, we talked about the difference between testimonial evidence and just straight evidence kind of thing. If I have a recording or someone's dying declarations. It's like, it's not the same thing as hearsay anymore. Dying declarations are a clear example of that. There's no way further to test that indicative reliability, but the context in which it was given is enough there that they can usually find that in. Okay. No longer an out-of-court statement, have some guarantee of trustworthiness, guarantee given the defendant's right to confront witness against him or her. Yes. So that's a shifting of how we look at it. That's important. Witness needs to be available. If they're unavailable, then had an earlier opportunity to cross-examine. So that's how they start dealing with that. So that's why they have the processes, all the questioning processes. I'm forgetting the name of the term, discovery, that kind of stuff. So you have all these opportunities for cross-examination, questioning, that kind of stuff. Ideally, I think we talked about in terms of best evidence rule. That's kind of also apply to witnesses to some degree. You'll want them there. In most instances, you'll need them to be there. Only in exceptional cases will it be that they won't be there. Oh, bright line. Confrontation guarantees cross-examination. Yeah. It's inadmissible unless they have an opportunity. Yes, that's Crawford. That's that bright line. Okay. Meaning of testimonial. Basically, does it require that confrontation clause? That's how they're doing it. That's how they classify it. If it requires a confrontation clause, then it's testimonial. If it's not, then it's not. It's difficult. Right? So is it a recording of someone talking, or is it the recording itself? The words in the recording are part of that conversation, but it's also, and so you can see where those things kind of blur up a little bit. Okay. Police interrogations. Yeah. Don't know if there's really anything that adds into that, because that's basically what you get there. We start dealing with that difference between testimony and non-testimony. It's sort of like the difference between, I think we mentioned in here. If I were to pull someone over, I suspect them of drunk driving, I'm going to ask them their name. It's not their name so much that it gives me any indication as to whether or not that they've done something wrong. So it's not necessarily that I'm hearing something that they're saying that they're testifying to give me that evidence that I need to prove that they're drunk. They're not confessing that they're drunk. It's the number of times that they slur, how much they drool, and that kind of stuff as they're talking. That's the difference between testimonial and non-testimonial. It's what you're taking from. Okay. States non-testimonial under circumstances, objective, primary purpose, interrogation. Oh, that's exigency clause right there. Objectively indicate that there's no such ongoing emergency, primary purpose interrogation established, prove past events. That's the relevant. So that's whenever the purpose is what dictates it there from a policing perspective. You're dealing with an emergency, exceptional. You're going to use this against somebody. Ooh, there's no emergency, and that purpose right here is used against them, because that's what kind of the default purpose is. Yeah, that's a problem. Okay, I don't know why that appeared so weird. Domestic violence trial. Officer's testimony from victim statements. Should not have been admitted. Reverse statements for testimony because they're not specifically obtained by the officer. Established events that previously occurred. So that's where they're getting back and forth on. Is it testimonial? Is it hearsay? And so here's where we start running some of the interesting things. It would be like another example would be, there's a case that has to do with the husband and wife exception. I can't remember what its name is, but basically it was, I think I told you about it already. Husband had killed a family member. I think it was the son, actually. They brought in the wife, and it was more of a social thing because they knew that that's the emotional right there. Stuff's going to come out. Well, you want to see her? Yeah. Okay. Well, we're going to stand right here in the room. And okay, that conversation, you think it's private, it's husband and wife, but there's a third party right there listening right there, and you know it. So it's not private at all. At that point in time, you start to move into different territory. It's no longer hearsay. Oop. All right. Ongoing emergencies. Is that a duplicate slide? Okay. Davis, Hammond, Bryant. Interrogation. Officer would consider testimony unless he made response questions. Yeah. Non-testimonial. All of these types of things, right? Whether it's the this is going to be dealing with measurements, that kind of stuff. This, well, Is that hearsay? Is it not? No. This is going to be the intent behind the words there. What you're doing is you're talking in code. And so again, it goes back to that purpose, right? That one. Anonymous tips. I won't talk about that here. I don't know if it comes up in here. It's more of a procedures thing. Essentially, whenever you had tips over here before, you'd have to validate to some degree both the person who gave the tip and the tip itself. It's like, well, what happens with anonymous tips? You might want to be able to stack on those. Certificates of nationality. That'd be like birth record. That's not testimonial. All right. Chemist reports were testimony admissible as business records. Based decision on record on their own without some test. Okay, that is a weird way of. I don't remember this case. So here's where we'll start getting into that difference between whether it's testimony or evidence. Is there opinion or interpretation involved, right? And so that's where you start getting into it, because you start getting into the difference between objectivity and subjectivity, right? It's my opinions involved. Then you're starting to get more towards that testimonial nature. This is my interpretation of what this thing says, right? In this case, sworn affidavits on the reports. They know its purpose, and it's to establish a fact. So that one would be testimony, because when you bring that person in, they're going to come in and they're going to testify to all of that, right? And so it makes sense. That's the way that would be classified. Next, analysts from test lab, Mr. Peter. Yeah, we've already talked about that. You want the person who does the testing here. They'll want to be able to be questioned, that kind of thing. Sometimes they'll do independent analyses depending on what you're dealing with. That's going to have to do more with the types of evidence that you have, how much is available, what kinds of tests are needed, how much are needed to run the tests. I mean, if you think back to like some of the early DNA stuff, like there were a number of times where DNA tests weren't run because the amount that was needed to be able to test it would use it all. And if you use it all, and there's nothing for the other side to go back and retest, which means it doesn't matter if you get a match or not. They can't prove it on their side too, so it doesn't matter. It never happened. That's how that works sometimes. I'm saying, yeah. Oh, too fast. Expert testimony forensics results. Interpret otherwise comment forensics report that's actually performing those tests. Okay, so that's going to have to do with the interpretation associated with numbers and that kind of thing. There's some degree of opinion on it, right? Is an effect size of 0.2, small, medium, or large? Who knows, right? That's going to be the person who's telling you about it. You're going to put some faith into them. Now, if you have two sides that are telling you two different stories, you're going to have to weigh out. That's going to be a lot more complex. Common case where DNA evidence is introduced. Why? Because what they'll do is they'll speak to the probability that this is a match or not a match. Oh, well, this percentage means that's like 1 out of 100,000 people. That's 1 out of 1.2 billion people. That's 1 out of 10,000. Oh, it's 1 out of 10,000. How many people are in town here? 16,000. Okay, so there might be 2 people here who can match that. Massively different odds across those 3 numbers, right? 1 out of 10,000, 1 out of 100,000, 1 out of 1 billion, right? Or 1 out of 1 million. Realize that when you have these people sitting on the stand, it's a funny way to put that. They'll be talking about them. There have been times where there have been people who have misstated those odds. Guess what? It's human to error, not necessarily a determining factor in and of itself. You have to look at the whole trial. That's how those things work. You have to be very careful with that. Okay, forfeiture by wrongdoing. Out of court testimony admitted without live testimony. Of course, I'm disagreed on what must be proved to invoke the doctrine. Supreme Court settled any question required relationship between forfeiture of wrongdoing and the confrontation. I need to look into that one. I don't actually remember that one. You forfeit your confrontation clause because you've done something. I need to look back in that one. I don't remember that one. Forfeiture of wrongdoing doctrines back will come places requiring defendant to make the intent to make witness. This is where you're purposely keeping somebody. Defendant murdered a girlfriend, forfeited his confrontation right concerning earlier statements, right? That's kind of stuff you get into. That person's been purposely kept. All right, well, we're gonna remove that because they did that with that specific purpose. That'd be like mafia, right? That person just disappeared. Okay, well, if we can prove that. Yeah, we don't really care about this so much because you did that with that purchase there. So we'll address that there. Here's where it talks about autopsy reports. Again, anytime you deal with interpretation, anytime you've moved into that area, you've added to some degree opinion. Oh, I spelled correctly. Opinion, which is getting right off in that area. Testimony, right? Okay. On presence of other purposes for autopsy reports. So that's two ways they do it. They either allow it in, recipient in the suite of autopsy if the medical examiner is unavailable, which isn't uncommon here, right? Courts rely on presence of other purposes for autopsy reports. So basically, they backdoor it just like you would an unwarned confession kind of thing. You find some other reason to get it in, and it serves both purposes, even though now it's kind of loophole. Firmly rooted exceptions. Basically, that confrontation only applies testimony. Right? Any statements that are not in that area, testimony or hearsay, no confrontation clause. So that takes care of that one. Exceptions. When reliability can be assumed. Hearsay is not admissible as evidence unless there's substantial reliability of statement. Long recognized common law exception to hearsay rule. I don't care about that part. That's just filling. Okay, here's where you start getting in some of those exceptions. So there are exceptions to hearsay rule. You can also look at it as some degree, it's also exceptions to your Miranda rights. This is just there's going to be an overlap there, right? Cited utterances, things that people say without having any provocation, right? The whole purpose of questioning or interrogation is to probe someone to pull out the information that you need. In this case, they're just giving it to you, right? Depending on the context of it. If ideally you're supposed to warn everyone of their constitutional rights before you get anything testimonial in nature. If you don't, you violated their rights. How can you stop them? You can't, right? Think about it this way. How many times is it that you get on someone who's unbalanced and you start to inform them of their rights? And as you're doing that, I know my rights. I still have to inform you. That's still part of the process. Are you able to get through that list of things you need to say before you're interrupted again? How many times is it they interrupt you, and with what can they say while interrupting you before it no longer is something that you have to be worried about getting that warning out? That's what this is about. I can't get this person to be quiet. I can't get them warning. They're just giving me this information, and it is so vital to have. We need to allow it in. A good example, I wish I could name the case, was someone showed up at the police station basically saying that he was told of God that he would go tell them what he had done. And he did, right? There's no warning there. Just, hey, listen, God told me I need to tell you I went and murdered all these people, and here's the evidence. Oh, crap. Yeah, we need to deal with that. We can't just let you go because you came in and told us about it. No. All right. Examples. Statements made immediately after shooting, stabbing, robbery, other types of criminal events, all that kind of stuff. Basically, it's one of the ways that you can get to the truth of it because the emergent nature of it does not allow one for maybe the time, the mental facilities to pervert the truth in their own interest, because it's short time frame, everything's critical, high number of eyes on it, that kind of thing. Okay. Next. Here we go. Mental, emotional, physical conditions. So here's where we start getting into whether it's the mental instability or any other reason, right? Statements of the declarant's existing state of mind, so preconditions. You're breaking that. It's going to be crazy. Okay. Reason for the exception is that if a statement is not offered to prove the truth of the matter asserted, Courts almost always hold that such statements are not hearsay and are admissible as evidence. Right? Next. Okay. Examples of existing mental motive, intent can be shown. Insanity or mental illness can be shown. State of mind can be shown. So those are all things that you can use that basically start to establish that. And they are, well, in that territory. Start looking at the product of what it is, right? That kind of stuff. What it produces. Okay. Horton versus Allen. Out of court statements of another participant in the robbery upheld the conviction. Yeah. Concluded the statements were non-testimonial. Okay. Treatment, medical diagnosis, that kind of thing. That right there. So that's one of those things that they won't necessarily, it's like you would, by default, these would not be allowed in. This would be kind of an exception kind of thing where your purpose here, your honesty with your doctor. It's the same reason why you have that patient practitioner relationship. You have to have that honesty there. And so the things that are said between there are assumed trustworthy. If for some reason you're getting a statement in that's outside of that patient client privilege kind of, it's going to have a stronger sense of reliability, right? Regularly kept records. Those aren't seen as, those aren't seen as hearsay because it's just regularly kept. It's not testimonial. It's just records. Okay. Dying declarations already talked about. These are instances where that person will not be allowed to be a witness. They're dying, right? You're going to give that some greater weight, right? And that just has to be under the belief of impending death, not actual death. If you say it, well, you think you're dying, you don't end up dying. Yeah, that kind of thing. Usually that's that person's gone, and that's why they're using it. For every exception, one's facing death, every motive, falsehood is silenced, mind is induced with powerful consideration to speak the truth. For some. Boom. Statements against penal interest. Personal interest. So this is one of those things. This is actually funny because this came up in a debate. I guess it was a debate, civil discourse thing recently. Statements against one's own interests are naturally given more weight because why would one provide information, testimony, evidence, something that is against their own interests, right? The reason that they do is because they speak strongly enough to the truth that the danger associated with which is no longer worthy of consideration, I guess. Call it sacrifice is another way of looking at it, right? I'm going to jeopardize myself in this way specifically to make sure that those who actually did what was wrong are identified and we're able to address it appropriately. It's a big danger, big one, right? This reason exception that such incriminating admissions or confession to order considered to be reliable, right? Because there's so much damage here that's like, yeah, why did I? Yeah, not many people would admit to something they didn't do. Some do, though. Okay. Fresh complaint outcry rule. So here's what we're talking about: hue and cry. That's actually the old way we used to do policing. Depending on what time frame you're talking about, you could be talking about within the city, whistles, bobbies, and that kind of thing. It's London, or if you're in the 1800s. Before that, you're talking about families. It's actually another thing they call tithings. So it was, what is it? Every 10th person, you get, and then 10 families, something like that. So you'd have your tithing is what they call it. So it's a way of informally having a mobilized force, military force is what it was. It was all informal back then. It was going to rally people up, and the next thing you know, you're fighting. Whether it's to go chase down a criminal or some other type of, that's because that's the time frame you'd be talking about here hundreds of years ago. Yeah, so in this case, it'll be the victim would be expected to cry out. Now, failure to do so, can't do anything about it. Why? Because it's a short time frame. No one's going to take the time to go back and talking hundreds of years ago. Talks about fresh complaints and that kind of stuff. What do I want to say there? Yeah, you have to file a complaint if you want any of this stuff to take place. If you're gonna, yeah, so big on that part. Common law assumed to be the victims. Consented. Okay, so this is where they start getting into the fact just whether or not that there is a complaint in the first place. That's one of those ways you start to identify who's what parties and where. In terms of this, there's a few different things that it could tie into that, you know, Bart talked about standing and that kind of stuff. Probably the part that's on my mind are things related to fresh versus stale, because some of these things have timelines to them. Most of the stuff doesn't, but you have statutes of limitations. Yeah. To infuse of assault, your testimony, witness claim third person told me committed the assault, used to prevent testimony, appealed. Yeah, no trustworthiness. There's nothing to that one. Moving forward. Okay. Out of court statements by children treated differently than adults. You get the reasons why. Right? You're dealing with different type of person there, different type of population. Yeah. And so they addressed that there. We'd addressed that earlier too. We talked about, I think it was infancy or something. Children have fully formed skills, less reliable, but also generally more truthful, less motives to lie, that kind of thing. Okay. Probably relate whether hearsay statements could be child witness or reliable. Here's how they've done it. Spontaneity and seeing consistency of repetition. So if it comes up on its own and it remains stable over time, its odds are it's not the kid. Right? Mental health, terminology. Right? What kind of language is that person using? Is that something characteristic of someone their age? No, okay, that's an outside influence. Right? Lack of motive to fabricate. That's another why. Next up. Okay. Statements made by a child to the police likely be classified testimonial. Not clear. The confrontation clause would have. That's actually kind of a difficult thing to deal with if you're in child cases. So you think about it, you know, whether or not the child's going to be required to take the stand, who's confronting, who's asking questions, and that kind of thing. And you always have the right to represent yourself. So imagine a situation where you're trying to deal with this criminal trial. You have a child witness, and the person's perpetrators wanting to represent themselves, right? And that's not good. All right. Ooh, that's the last of that one. Yay. Cool. So the next one is where we start getting into the exclusionary rule. But first, we'll do a little bit of fun. Split screen. See the whiteboard. Oh, yeah. I really wasn't we're just talking about the stuff that was on the slideshow. And so stuff is going to put up over here. So as we're getting ready for the exam, let's go through standard format, as always, was it 45 multiple choice questions, one essay, 10 points on the essay, chapters 5 through 8. And so let's talk about the things we need to know. When someone is impeaching a witness, what are they doing? What is the purpose of impeaching a witness? Right? When we start talking about the roles in terms of like who does what, examination, cross-examination, that kind of stuff, where would you expect to find someone's witness being impeached? That kind of thing. Let's see. if you're going to be a competent witness, what is it you need to be? Right? What is it that a competent witness needs that when you take the stand? And that would be lay witness, not necessarily expert witness, but it's kind of the same thing. Okay. What's the difference between, well, no, not really in here. Direct examination. Yeah, that's a simple one. Next, yeah. Confrontation clause. What constitutional amendment will you find it under? That. Okay. That's going to be a big one. You should know, of course, self-incrimination, confrontation clause for this one. I'm trying to remember if you need to remember the jury one for the last one, if that's this. We'll see if it comes up. Okay. That's pretty straightforward. Who determines the competence of witness? Okay. When you have the jury and they're looking at the evidence, how should they weigh the evidence? This would be an old one. I don't know if they've got a question on this one yet or not. Direct versus circumstantial. Always keep that part in mind. That ability to make inferences is very, very useful. Okay. Expert witnesses. Usually what comes up with that, if there's an essay on it, I'll tell you about it, but usually you want to do with the Fry and Daubert standards, know what those are. Let's see, what else do I want to tell you about that? Let's see. Yeah, I was just asking about expert witnesses' opinions. Okay. Sixth. Next up. Subpoena duces tecum. Don't ask me how to pronounce that. That's Latin. That's that this one right here. You may be asked what that phrase means. Don't ask me, I don't speak Latin. All right. When we start talking about privileged relationships, know what they are. When we start talking about husband, wife, clergy, attorney, doctor, all of those types of relationships, know what those exceptions are, know why they exist. What is a judicial notice? What is it used for? Stipulations. What are stipulations? Journalists' qualified privilege. What is their qualified privilege relate to? It's a good one. Let's see. First, Fifth Amendment, Sixth Amendment stuff here. Attorney-client privilege is one of those privileges. Most of those privileged relationships. When is it you can have that privileged relationship with someone, but it has none of the protections associated with it? Like I have an attorney, but there's no attorney-client privilege. Or I have what would it be? A doctor, right? But for some reason we have no doctor. It's because we're involved in some type of criminal pursuit, right? The whole purpose of that relationship, if that's for the purposes of criminal pursuit, there is no relationship privilege there. So if I marry someone just because of the fact that I'm going to use that person as a way to establish a multi-country drug organization, something like that, it's like that marriage isn't real. It's like that's not the same thing. That's something different. That's something criminal, and we'll treat it as such. That kind of a thing. Or a lawyer. I got a lawyer because I'm trying to figure out how to issue payments to somebody illegal. It's like, if that's the purpose why you have that lawyer, that's not a lawyer. That's a criminal associate. That's different, right? And so it's a real hard distinction to make, particularly when you deal with lawyers. I'm just kidding. All right. Judicial notice. When we're talking about that, what is its purpose? What does it do? Let's see here. Judicial notice, one judicial notice, testimonial evidence. More on relationships. Not too shabby. This shouldn't be that hard on y'all. When can you assert your privilege against self-incrimination? Yeah. All right. Questions about whether stuff is testimonial evidence. This one's medical examiner further testifies about blood, DNA samples, that kind of thing. Is that, is it not? Let's see here. Hearsay is an oral statement, yes. Declarants and assertive statements. When we're talking about hearsay or not, the declarant's the person who said it, and if it's an assertive statement, it's basically something that asserts some, what would you say, matter of fact, something of that nature. 1603. I think they're probably referring to Walter Raleigh. If I said Walter Raleigh, we talked a little bit about him. He's the one that they open up, I think it's the hearsay chapter on. Remember, he is the, I don't know what country he was in. Some type of named person, had supported their country, was eventually killed because of what someone had said, he had said kind of thing. Yeah. How they handled hearsay back then, not good. Say accusatorial. Testimony. To fall within the hearsay rule, testimony that must be offered to prove the truth of the matter asserted in the statement. Right? Remember that phrase, the truth of the matter asserted in the statement. Let's see. It's hearsay if you did not personally witness the event. That's just simple stuff there. Actually, ex post facto confrontation clause. I already talked about some of the conspirator stuff. So that's yeah. Okay, be familiar with Washington v. Crawford. Those cases, that one will come up as a named one. Not seeing too many that are named, but that one is.
Professor, your students.
Yeah. It's possible to put on split screen. Yeah, I could, but at this point, I need to write names. There's nothing really on the screen anyway. I probably could move it over though. Let's see here. Is it this way? Is it me? Or am I going the wrong way? Yeah, here we are. Cool. All right, so be familiar with the different exceptions to the hearsay rule whenever stuff is no longer testimonial, but what would you say? Evidentiary in nature. No longer testimony is testimony versus documentary evidence, that kind of thing. Think of the recordings, right? Is it the communication or is it the recording? Is it testimonial or is it not? From there, here, excited utterances, dying declarations, those types of things we covered today, those types of exceptions. And then we should be to the essay. All right. So there are 3 possible essays. First one, define hearsay and provide an example. Be sure to explain why the example meets the definition. So you'll need to talk about statements, you'll need to talk about declarants and the difference between, testimonial and non-testimonial evidence in that one. Next one, describe and discuss Sixth Amendment rights of defendants with regard to witnesses. Basically, we start getting into is that compulsory, that subpoena process there. Know its importance, what it does, what it means, and how it basically affects the ability to test whether or not the information being provided at trial is accurate. Okay, so discuss the objections which attorneys make to both questions and answers directed to witnesses in a criminal trial. That's actually a really good one. Because it identifies the different typologies of objections. One to the, what was it, the form, the substance, and then the answer, right? Form of the question, substance of the question, and the answer, if I remember correctly. Basically, what you start identifying there is one, those objections need to be made contemporaneously. So if you miss your chance, it's like, boy, you might miss your chance. But two, it's like these are the ways in which people start to change that landscape of the discussion. I'm going to phrase this question in a nasty way to give it this kind of an impression, this kind of an inference, without necessarily meaning to those softer approaches. That's how those things start to go that way. And with that, yeah, that covers it for the review. We finished out that chapter. We'll start up with exclusionary rule stuff next time. Does that sound like fun? Cool, cool, cool. All right. With that, we are pretty close to back on schedule. Went a little bit faster, a little drier today than I'd like. I would have made a little bit more conversation, but we lost all of last week. And sorry about that, but we'll make up for it. You all have a great day, and I will see you all on Wednesday. If you need anything, let me know. And other than that, take care and have a great day.